Good afternoon. I'm Laura Weinrib, and it is my great pleasure to welcome you all to the 2014 Fulton Lectureship in Legal History. The Fulton Lectureship began in 1985 because of a gift from Maurice and Muriel Fulton. Maurice earned his JD from the law school in 1942, and both he and Muriel are graduates of the college. For almost 30 years, the Fulton's generous support has brought to the law school some of the most distinguished figures in the field of legal history. We are thrilled that the Fultons are here to join us today, and I'd like to take a moment to thank them for making this incredible tradition possible. I'm delighted to introduce this year's Fulton lecturer, Tomiko Brown-Nagin, the Daniel P.S. Paul Professor of Constitutional Law at Harvard Law School and a professor of history at the Harvard Graduate School of Arts and Sciences. Professor Brown-Nagin received her PhD in history from Duke University, and while she is a graduate of the Yale Law School, I've just learned that her husband, Daniel Nagin, is a graduate of our law school, so we can claim her as an alumna through marriage. Before joining the Harvard faculty, Professor Brown-Nagin held joint appointments in law and history at Washington University and then at the University of Virginia. Professor Brown-Nagin has published widely in the areas of constitutional law, education law, and inequality, in addition to social and legal history. Her work has been extremely influential. In fact, it wouldn't be an exaggeration to say that Professor Brown-Nagin has helped to redefine civil rights history and to shape the historical understandings as well as the research agendas of emerging and established scholars in the field. I want to say a word about Professor Brown-Nagin's path-breaking 2011 book, Courage to Dissent, Atlanta and the Long History of the Civil Rights Movement. In my 20th century legal history class this Tuesday, we were discussing new directions in civil rights history, and I put up a PowerPoint slide with the most important new developments and areas of research in the field. In every one of the categories I discussed, I foregrounded Courage to Dissent. It's hard to do justice to the book in just a few words, but in a nutshell, Courage to Dissent redirects attention from the well-studied national actors in the civil rights movement to their local counterparts, who negotiated and implemented the Southern struggle for racial equality. What the book highlights is ambivalence and contestation at the grassroots level, the class, generational, and ideological differences among Atlanta's civil rights lawyers and activists. And by paying attention to these conflicts and complexities, Professor Brown-Nagin developed crucial new insights not only about the civil rights movement, but also about the nature of legal change, the competing demands of the legal profession, and the power of social movements. In recognition of these impressive achievements, Courage to Dissent was awarded a long list of prestigious book prizes, including the Liberty Legacy Foundation Award from the Organization of American Historians, the Lillian Smith Book Award, the John Philip Reed Book Award from the American Society of Legal History, and of course the Bancroft Prize, which is the highest honor awarded annually in the field of U.S. history. Professor Brown-Nagin is currently at work on two books, one of which is a biography of the pioneering civil rights lawyer, politician, and federal judge, Constance Baker Motley. We'll be hearing more about that exciting project today. The title of Professor Brown-Nagin's talk is The Honor and Burden of Being First, Judge Constance Baker Motley at the Bar and on the Bench. Following the lecture, we'll have time for a short question and answer session, after which we invite you to join us for a reception outside the courtroom. With that, please join me in welcoming Tomiko Brown-Nagin.
Thank you. About 40 minutes. Thank you so much, Laura, for that very, very kind introduction. I really appreciate it. I should start off by saying thank you to the Fulton family for sponsoring this lecture. It's so important to recognize the field of legal history for its unique contributions to the law and to scholarly understanding. And it's so lovely to be here at the University of Chicago. This is my second time here this semester. I participated in a conference celebrating the 50th anniversary of the Civil Rights Act not too long ago here. There's always excitement here, wonderful work going on. It's so wonderful to see so many familiar faces. I see while, of course, all of the distinguished legal historians in the Chicago community. I see at least one Motley clerk who's been helpful to me already in this project. I even see a graduate student that I tried to recruit to Harvard who ended up here. So our loss is your gain. I am delighted to be here to speak about the great Constance Baker Motley. I'm writing a biography of Judge Motley, who was the 5th woman to be appointed to the federal bench and the first African-American woman, appointed after a distinguished career as a civil rights lawyer. She was a pioneering woman lawyer who was known for her grace, for her dignity, for her intelligence, also for her deadpan wit. She was known for her commitment to gender equality, a commitment that was shown perhaps through her favoring of male clerks for certain assignments in the chambers, such as, the making of the coffee. And I'm also told that when she went on strolls in Lower Manhattan, she tended to have her male clerks hold on to her purse. She perhaps engaged in some role reversal for equality there. Well, this year is an auspicious moment to consider the life of Judge Motley, because, as I mentioned, this is the year in which we marked the 50th anniversary of the Civil Rights Act, the passage of the Civil Rights Act, of course, the omnibus law that banned discrimination throughout public institutions. Here I have for you this famous photo of President Johnson signing the bill into law. There you'll see that he's surrounded by senators, he's surrounded by Dr. King in the background there. They are smiling, they are ecstatic, and President Johnson, of course, saw this law as one of his crowning achievements. He said, when he discussed the meaning of the anti-discrimination law, that it represented the abiding commitment to freedom in this country and our constant pursuit of justice. Now, President Johnson was also the president who nominated Constance Baker Motley to the bench. So he showed his commitment and the country's commitment to equality and to justice through that nomination. And in many ways, you can say, Constance Baker Motley personified the struggle for equality and even its realization in the same way that Johnson thought the Civil Rights Act personified the realization of equality. What I hope to discuss here today is the way in which Judge Motley embodied the struggle for equality, but also the way in which her life in the law allows us to meditate on the limitations of the law as a way of achieving equality. And you should know that when I talk about both law as a means of achieving opportunity, realizing opportunity, as well as seeing the limits of the struggle for opportunity in America, I am in some ways channeling Judge Motley. In 1989, Motley was a keynote speaker at a celebration of the 25th anniversary of the Civil Rights Act, and she emphasized at that moment that it was no time to think of the Civil Rights Act in terms of nostalgia. She said, after all, that the Civil Rights Act was not exactly a revolutionary idea. Judge Motley said that the act simply enforced the 14th Amendment after a century, almost a century after it was enacted. In other words, she said, after all of that time, Congress finally got around to enacting legislation that was necessary and appropriate to secure the promises of Reconstruction. Thus, in Judge Motley's view, the emotion that should go along with thinking about the Civil Rights Act was less ecstasy than relief. Nothing revolutionary about the Civil Rights Act. In fact, she emphasized, and I would emphasize, that the revolution was in the people themselves, And thus, when Motley talked about the anniversary of the Civil Rights Act, what she did was to talk about all of the people, including her client, who had participated in laying the groundwork for the enactment of that law. Thus, in this address, I'm going to talk about the Civil Rights Act in the largeness of its meaning, and I'm actually going to position Judge Motley and her life and work as a way of thinking about the Civil Rights Act and thinking about this question of whether or not we should view it and view her actually in revolutionary terms. Now, Motley certainly was perceived as a revolutionary. She was discussed as a threat to the social and political orders when LBJ proposed her nomination to the bench in 1965. And so what I hope to do is to consider what all the fuss was all about. What was the fuss all about? But before I consider how that analysis should look, first, let me introduce those of you who may not know much about Judge Motley to this woman whose novelty and audacious moves in the courtroom made her an icon of equality, caused some to call her the Civil Rights Queen. The first thing that I will emphasize about Motley's biography is that her narrative is an incredible story of ascent. She was born in 1921 in New Haven, Connecticut. She rose from abject poverty in New Haven. Her family was from the island of Nevis, Caribbean island, the same island where Alexander Hamilton hailed from. The family grew up in the shadow of Yale University. Her father was actually a chef for Skull and Bones and other, yes, he was. It's almost too good. Poverty, Motley said, was omnipresent in her youth. Her family survived the Great Depression by, quote, literally eating the crumbs that fell from the tables of Yale's wealthy sons and daughters. So her father, who was this chef for the social clubs, would actually bring home food. The thing that's so interesting about Motley having grown up in the shadow of Yale is that it did not inspire any resentment. Not at all. Instead, the family, they were inspired by living in the shadow of Yale. Motley had a lot of gratitude towards Yale, as did her father and others in her family. It inspired this young girl, intelligent girl, to strive. She grew up in a multi-ethnic community of strivers. Her parents were, they're very moralistic. They were third-generation Anglicans who spoke with British accents. They were fond of hearing God Save the Queen on the upright piano that sat in the corner of their tiny home. The father thought that their family and other West Indian blacks were superior to black Americans. And this viewpoint he shared with Motley often. The viewpoint was derived from the fact that his family was a family that descended from free people and also descended from whites, and so he taught that they were different. And Motley believed that she was different, and she had this sense that she was different confirmed when, as a young girl, she gave an address at a community center in New Haven, and a philanthropist overheard her talk and offered to pay her way through college and law school, and did so. She said that it was like a fairy tale, like a fairy tale. The only catch was the man's age. He was very, very old, and she was in constant fear that he would actually die before she could complete her time in college and law school. So she actually, and you have to think about the psychology of this really poor girl who had this blank check presented to her. She was grateful, but also literally fearful. And so she enrolled in college on an accelerated course and graduated from college and law school in record time. Then the question is, well, what did she do with herself? And what she did was to work at the NAACP Legal Defense Fund for 20 years. And here's this photo that speaks 1,000 words. She was hired by Thurgood Marshall in 1945. She worked as the only woman among a group of men, high-powered men, highly intellectual men for all of that time. And she was highly successful. So there's Jack Greenberg there, there's Derek Bell there, James Nabritz, a lot of folks who are very well-known lawyers. Motley was a successful trial lawyer. She argued 10 cases in the Supreme Court. She won 9 of them. She argued numerous cases in the federal appellate courts and trial courts. Her trial work and appellate work desegregated higher education in the South. She litigated the cases that desegregated the University of, Ole Miss, perhaps her most famous case. There she is with Jack Greenberg and James Meredith. She litigated the case, the University of Alabama. There she is with authoring Lucy and Thurgood Marshall. Lucy is there in the middle with her Bible. She certainly needed it. She litigated the cases at the University of Georgia, at Clemson. All of those cases were Motley's cases. She worked on K through 12 school desegregation cases, Atlanta, New Orleans, and then she also was Dr. King's attorney. She was the attorney for the Birmingham Children's Marchers. Motley was just an incredible, a superb lawyer. She was considered an invaluable member of LDF's legal team. She impressed not only the lawyers inside of LDF, but observers outside of the law firm. Justice Douglas called her one of the ablest appellate advocates he'd ever seen. Ramsey Clark, Attorney General, saw her argue and recommended Motley for a federal judicial appointment. But all was not rosy at LDF. In fact, the biggest disappointment in her career occurred while she was still there. In 1961, when Thurgood Marshall, her mentor, and I don't know if you can see from this photo how her eyes are shining. Marshall was truly her mentor. She gave him tremendous credit for hiring her at a time when no one else would. But when he passed her over for the job of director counsel in 1961, instead choosing Jack Greenberg as successor, she was stunned, as were, every other African-American lawyer in the country, who assumed that Marshall would turn to a charismatic lawyer inside the civil rights movement. There were many. The decision rankled Motley, though, not on grounds of race as much as grounds of gender. And here's what she had to say. Marshall, quote, had difficulty with the idea of a woman in a leadership role in a male world. And it's this discomfort, she said, that dashed her hopes of obtaining this coveted opportunity. So this is remarkable to consider that Justice Marshall, who undoubtedly was a champion of civil rights, liberal lion on the Supreme Court, including in sex discrimination cases, he's the one who sits at the center of this painful episode of what Motley viewed as gender bias in her career. Thus, her career at the Inc. Fund turned out to be bittersweet. The question is what to make of this information, how to think about it. And for me, I start to ponder the interaction of race and gender, and I start to think about, well, what discrimination might mean in this context. Of course, it's important to consider what the actors in this drama had to say for themselves. When Marshall was questioned about this episode, he said, well, Jack Greenberg had 6 months seniority over Motley, which seems like an oddly thin explanation. I have looked at the evidence that's available, interviewed a number of people, and here's how I've come to think about this. I'd suggest that there are two rationales for the passing over of Motley. One has to do with her relative inexperience in the organization's decision-making structure, which is different from her experience as a lawyer. And then the explanation that goes to the possible diminished credibility for LDF given prevailing gender norms. Now, regarding her relative inexperience, it turns out, according to Robert Carter, who was Marshall's second in command, that although, yes, Motley was a superb lawyer and a very active member of the legal staff, she had not been a part of the inner circle in which Marshall and Robert Carter engaged in, quote, conceptual analysis. Now, if it's true that Motley was removed from conceptual analysis, then it might make sense that she would not be ready to take over the reins of the organization. But of course, her removal, if it's true, from this inner circle only begs more questions. Why, if she was such a great lawyer, was she removed from the inner circle where conceptual analysis occurred? That is the question. And why, if Jack Greenberg also was not a part of that inner circle, was he not disqualified from the position? It's likely that gender had something to do with her absence from that inner circle. The rationale that turns on prevailing gender norms is a more difficult rationale. If you think about, or perhaps you want to say more credible rationale, if you think about how Marshall would have thought about his responsibility to the organization, as a whole, and the reality that no civil rights organization at this time had a woman leader. Within this context, it's just not surprising that gender factored into Marshall's decision-making. Whatever her disappointment with Marshall's choice as successor, Motley adored him. And as I said, she acknowledged that Marshall made her career. He had hired her at a time when no one was hiring women lawyers. He had hired her in 1945 at a time when other lawyers took one look at her and essentially sent her on her way. And so she was grateful to him. If it had not been for Thurgood Marshall, she acknowledged, no one would have ever heard of Constance Baker Motley. At the same time, she admitted, Marshall had more faults than one could shake a stick at. But like other great men, he had qualities which could only be described as noble. And thus, what I would say is that putting Motley at the center of the conversation complicates received wisdoms about Marshall and about LDF, this premier public interest law firm in the post-war era. Motley did not stop in her career after LDF. The next phase of her career was in New York City politics. Very few people know anything about this. In this photograph, she is being sworn in as Manhattan Borough President. She was the first female Manhattan Borough President. She also was, for 2 years, in the New York State Senate, the first black woman in the New York State Senate. In this capacity, she pursued the agenda of a liberal New York politician. Urban renewal, she sought more resources for schools, and so forth. I won't, in this context, have a lot to say about this phase of her career, except a couple of things that are notable for her judicial career. It's when she's in politics that Motley, for the first time, has to address questions about identity and leadership that she never had to address when she was a civil rights lawyer. And everyone accepted her as being a legitimate black leader. She also had to answer questions about gender that she had not had to answer before. On race, she had to start to speak to the question of, well, so what kind of black are you really? And this is in the context of Malcolm X and Black Power, and here's what she had to say. I say that Negroes, like whites, are diverse people. Some of us are conservative, some radical, some middle of the road. We have as many faces as the white man, and like other ethnic groups, we have a variety of organizations which differ markedly in structure and philosophy. This is as it should be. This is as it should be. And she was middle of the road in the context of Harlem politics. Some people did not accept her. Then what about gender and identity? Well, there was much chatter about the significance of her being a woman and holding elective office. People wanted to know if she was a woman's libber. And she rejected any suggestion that she was. She said that she had been too busy eliminating discrimination against race to fight discrimination against women. Well, if only it were so simple. Of course, it matters that Motley held elective office when she made that statement. She was being asked these questions before the women's movement actually gained full steam. It was really just getting started. It would not have been in her interest, even in New York City, to be called a woman's libber or a feminist. And she did not want to be called a feminist. but she did not object to editors of the New York papers calling her the feminine boss of New York. So she's threading the needle there. So I call that a clever woman. And in the context of my project about Motley and trying to position her within gender politics, I am arguing that it's quite necessary to move away from using feminism and those who accept the label as a proxy for those who actually contributed to the struggle against discrimination. Certainly, as we have seen, Motley suffered on account of her gender, and certainly, as I hope to show, she made tremendous contributions in that struggle against gender-based discrimination. So we should have a more capacious understanding of those who made such contributions without demanding that they embrace labels in the way that someone like a Pauli Murray did, or Ruth Bader Ginsburg, or even Betty Friedan, who, by the way, was Motley's friend, but not from any consciousness-raising circles. They were fellow mummies at the Dalton School, where they both had children. What else about this period, her role as a legislator? Well, I actually think that there's some evidence that it affected her judicial philosophy. There's a real sense that Motley understood the distinction between the role of a judge and the role of a lawmaker. As a judge, she expressed the view that she should give the broadest interpretation to statutes intended to remedy an injury or a violation of rights. But unlike some judges, some colleagues, some of her friends like Judges Pollack or Weinstein come to mind, she actually took pains to, well, she didn't view herself as a policymaker or as stretching the law, pushing the boundaries of the law in a way that was akin to policy making. She had been a policymaker as a New York legislator, but on the bench she actually tried to observe boundaries between those roles. Now, even as I say that, we know that that can be difficult. The important thing is what her aspirations were. Now, let's move to her career on the bench. As I said, Motley's career as a judge was as a result of the nomination of LBJ, president who nominated her to the U.S. District Court in 1965. It was not smooth sailing. The senator from Mississippi, Eastland, and some others question whether someone who was a civil rights lawyer could be fair. Could she be fair? They asked. Eastland called her a communist. He called witnesses from early in her life in New Haven and in New York to essentially inform on her. He actually subpoenaed a former associate of Motley's, an older woman by this time, and called her in and accused Motley of attending meetings of the Young Communist League in New Haven and of following Lenin. To which the woman responded, "Who's that?" And she also said, well, if Motley had attended any meetings in New York as a young girl, it was at the St. Luke's Episcopal Church. Of course she was there, and so Eastland's bit of political theater failed miserably. But the idea here, what Eastland is getting at in his dramatic way, is something that was a real problem for her and not only a sentiment emanating from someone like Eastland. It was this assumption that a civil rights lawyer would, on the bench, translate into an unabashed liberal. The resistance and this sentiment not only came from Eastland, it came from Wall Street lawyers, a lot of folks in New York who wanted other people to attain the seat that Motley eventually was appointed to. In fact, Motley, LBJ, originally wanted to nominate Motley to the Second Circuit, and there was tremendous pushback. All of it, most of it, a lot of it, having to do with her having been a civil rights lawyer, the idea that, well, she couldn't handle securities cases. What did she know about securities cases? Same thing was said about Ruth Bader Ginsburg, by the way. I won't go into that. I will say, though, that her confirmation process took 7 months, so it was delayed, but she finally prevailed. Thurgood Marshall, by the way, who of course had his own problems with Senator Eastland during his process at the Second Circuit and the Supreme Court, she said, held her hand during the entire ordeal. She was finally appointed in 1966, and the one-word header of the White House memorandum that announced Motley's appointment spoke volumes and ensured a place for Motley and for LBJ in history. The announcement simply said, first. First. Constance Baker Motley was the first Negro woman ever appointed to a lifetime federal judgeship. That's what the memo said. Civil rights groups, women's rights groups hail the achievement. And, you know, the story could end there. If all we want to do is to celebrate, we can end our discussion there with her having been a first for all those years at the Legal Defense Fund, a first in New York City politics, first judge. We could just say she's a civil rights queen and end the book, and that's sort of appealing. But my version of legal history won't let me end the story there. We have to engage in a much more complicated analysis. We can't end the story there in part because the resistance did not end there. After Motley took the bench, she faced repeated calls for her to step aside from cases, including cases where she was interpreting the Civil Rights Act on grounds that she just could not be fair. Perhaps the most famous case was Blank versus Sullivan and Cromwell. Yes, that's Sullivan and Cromwell. The case was filed in 1975 by law school graduates, female law school graduates, who alleged a pattern and practice of sex discrimination at the white shoe firm for refusing to hire well-qualified female attorneys and subjecting them to less favorable working conditions than men. Motley drew the case, and so it fell to this famed civil rights lawyer to preside in one of the first cases where the principles of Title VII of the Civil Rights Act would be interpreted in high-status jobs. The law firm's attorney was not happy. He protested. He said that Motley should withdraw from the case. He wrote her a letter saying that as an African American and a woman, the judge likely had experienced workplace discrimination. And here's what he said: I believe you have a mindset that may tend, without your being aware of it, to influence your judgment. So in essence, London was arguing that only white men could properly preside in a sex discrimination case. Well, Motley would not remove herself from the case. In a short opinion, she explained that the lawyer for Sullivan and Cromwell had not actually met the requisite legal standard, which required evidence of personal bias as opposed to conclusory statements alleging this amorphous bias connected to identity. In her opinion, Motley noted that in her 9 years of work on the court, she had ruled against plaintiffs in civil rights cases and against women in workplace discrimination cases, and these rulings show that she could be impartial. After analyzing the black letter law distinguishing between personal bias and these kinds of conclusory statements of bias, she got to the heart of the matter. Could a female impartially preside over a controversy in which gender discrimination was alleged? Yes, she answered. It is beyond dispute, and I'm quoting, that I am a woman, and before being elevated to the bench was a woman lawyer. However, if background or sex or race of each judge were, by definition, sufficient grounds for removal, no judge on this court could hear this case, Motley wrote. So in other words, the judge had turned the lawyer's argument on its head. Every judge has a race and a sex. And so this argument, if taken to its logical conclusion, would undermine every one of her colleagues. This opinion by Motley is a classic. It's cited in treatises, tightly argued opinion, very much like many of her opinions, for the proposition that race or sex alone or prior practice experience cannot disqualify a judge from presiding in a case, because all judges have a background, experiences, associations, and viewpoints. This opinion, by the way, was cited time and again when there were calls for the judge in the California same-sex marriage case to recuse on much the same rationale. So there are many of these recusal motions. Now I want to talk about the substance of her rulings. Motley was on the bench for 39 years, and in blank, she emphasized that, well, she had ruled in favor of defendants in these sex discrimination cases and race discrimination cases on many occasions. Well, that is true, but it's also the case that she issued landmark opinions that opened up the workplace for women. She implemented the Civil Rights Act, Title VII, or important equal protection cases involving sex. One of them was Lucky versus Time Warner, where Motley toppled a bastion of male dominance and exclusion, which was the locker room of the New York Yankees. This was a case where a journalist for Sports Illustrated had attempted to enter the locker room of the Yankees during the World Series. She wanted to attain post-game interviews of the ball players, and she was denied as a matter of policy. No women allowed. Lucky sued. Again, Motley drew the case. She found that the Yankees ball players' interest in privacy was not strong enough to exclude all women from the locker room. Can't be an all-male preserve. Some interesting material in that case about a lot of issues, but in the interest of time, I want to focus again on the pushback against Motley. Ferocious pushback, perhaps the most of any in Motley's career. And let me give you a taste of it by quoting from one letter writer. He began his attack on Motley's decision with a candid confession. Call me a male chauvinist pig, have a bra burning on the front lawn of my house, shred my wife's copy of Miss Magazine, he argued, but women do not belong in the Yankee clubhouse. No, 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 1,000 times no. And as for Judge Motley herself, he spewed, how ironic that she would rule. So everyone is very conscious of her prior work in discrimination cases. Motley, by the way, was not bothered by any of this rhetoric at all. Her response to the dilemma that the male athletes faced was, well, let them wear towels, cover themselves up. The concern was that the female journalists would see the ball players parading around without any clothes on, and she thought, well we can handle that without excluding the women completely. There are many other cases where Motley ruled in a way that was consistent with this idea that she was a champion of gender equality on the bench. A case late in her career involved the financial services industry, Smith versus Martins. It was a class action suit where female brokers alleged discrimination against the New York Stock Exchange, and they alleged differential pay, lower status positions, retaliation, again under Title VII in the Equal Pay Act. This case, by the way, was also known as the Boom Boom Room case. So named because there was a room in this, one of the prestigious investment banks where Wall Street brokers invited, exotic dancers, I'll call them, to lighten the load during the workday. This was a case where there were high-profile lawyers on all sides, and the long and short of it is that Motley eventually approved a settlement that involved complex remedies, and again, the newspapers highlighted Motley's civil rights background, and the outcome confirmed what everyone knew. And I will say that it's because of this ongoing sense of Motley, in part, that she was never elevated to the Second Circuit. In my work, I was very curious about these repeated allusions to Motley's background in the context of outcomes in these kinds of cases. I am aware of political science literature finding a correlation between gender and judging in employment discrimination cases and certain kinds of criminal cases, but I wondered if high-profile cases might be misleading. I wondered if she truly was so pro-plaintiff in the way that these high-profile cases suggest. I wondered if the publics and scholars need to see her as the civil rights queen. To view her as an icon might actually obscure analysis that might speak more generally to larger questions about judicial appointments, about judging, about the opportunity in law, about the Civil Rights Act and its potential over the long term. Is it really true that advances in equality are as easy as appointing lawyers with public interest backgrounds to the bench? These are the types of general questions that present themselves in the context of this study of this judge that are relevant to our time. And so what I have done is to actually engage a different type of analysis to try to begin to answer these questions. Now, unfortunately, these slides as presented here won't allow you to see very much of the detail here. So we'll just have to take my word for what I'm telling you. what I decided to do is to, in addition to reading cases in the way that an historian does and trying to engage in qualitative analysis, was to actually, with the help of a statistician, engage in some quantitative analysis, some coding. And what we did here was to actually gather all of Judge Motley's decisions for all of the time that she was on the bench in the categories of cases that the political scientists think are those where you can smoke out a judge's ideology. And we actually were interested to know, well, how often does she rule in favor of plaintiffs? And if you actually can see there, you'll see something that I will change in subsequent presentations. There is a red bar and a blue bar. The blue bar right now says liberal. It should say plaintiff. Those are pro-plaintiff decisions. The red bar says conservative. It should say pro-defendant. And not only did I pull together results from all of these categories for Motley's cases, but in order to have them make sense, you have to compare her to someone, right? So we compared her to judges on the Southern District of New York who are close matches to her. So for Motley, this is Robert Carter, who is a black man who, I mentioned him before, Thurgood Marshall's second in command, similar practice background. So you want to find judges who are the same except in terms of the variables that you're interested in analyzing, race and gender here. So Bob Carter, and then we went to Ed Weinfeld. Some of you, many of you will know him by reputation. Again, on the Southern District of New York. And then we had to go to June Green, who is on the district court in DC. Why did we have to go to June Green? Well, because there's no one to compare Motley to on the Southern District of New York in terms of gender, because she was such a pioneer. And the question that we're asking, again, is whether race and gender seem to matter to the outcomes in these categories where ideology, according to political scientists, seems to do a lot of work, or at least some work, rather. And here's the question that the statistician and I came up with. And the answer is yes. And for the male judges, the correlation runs in the direction that many people would expect. Okay, so Bob Carter is more likely to be pro-plaintiff than Ed Weinfeld. But for the female justices, the correlation doesn't work out in the way that is expected. That is, Judge Motley is less pro-plaintiff than June Green. And in the category of cases that I'm most interested in, which is the employment discrimination cases, and as to the two judges that I'm actually really interested in comparing, which is Motley and Weinfeld, for reasons that we can talk about in Q&A. They were actually competitors for a Second Circuit judgeship, and it had a lot to do with politics and these questions that I'm talking about. There's no difference as to this correlation between race and gender. She doesn't turn out, in other words, to be the pro-plaintiff kind of judge that, well, some liberals might have liked, and some folks who had been opposed to her or for so many years feared. Now, I will emphasize that I pulled together this kind of empirical analysis to complement the work that, frankly, I think is more nuanced, and for me as an historian, more important. It's the qualitative analysis. And there are lots of questions, lots of ways that this data can only tell us so much, and I'm happy to talk about that. But the most important thing that we can conclude here is that when you compare Motley to colleagues on the Southern District of New York, she's not particularly pro-plaintiff, but of course, if the baseline is, say, the District of Mississippi, she probably is particularly pro-plaintiff, right? So your baseline matters a lot. Other thoughts about what we can tell in terms of Motley's impact. Well, she did make a real impact in a particular category of cases, discrimination cases. And this is a qualitative analysis. What cases would you suppose those are? Well, those are Title VII cases involving sex discrimination against professional women. These are cases where she blazed a trail, particularly in the early years. So cases against women journalists, lawyers, professors. These are cases where women are trying to break the glass ceiling, and Motley made her mark there. But in Title VII race discrimination cases, there are, frankly, remarkably few victories that I've seen thus far for plaintiffs. And the cases where there are victories are instructive. One of them is Evans versus Connecticut, where it's a Title VII employment discrimination case where Motley pulls out all the stops. She has Burke-Marshall come in as a special master to help to parse the evidence in the case. The plaintiff is a police officer, and the police department had been sued before. It had been under a consent decree. So this is a case involving, you might say, the perfect facts. And I could go on, but the idea is that in cases involving unremarkable facts and the average Joe, Motley doesn't look that different than other judges. She tossed out suits brought by prisoners against corrections officials. She sentenced perpetrators of crimes to long terms in prison. She entered judgments for big corporations. She behaved in a way that many federal district court judges behave. She decided in a way that is typical. Let me conclude by offering additional thoughts on this question of, well, what we can say about whether Motley is revolutionary, whether over the long term this act looks revolutionary. I said that Motley was perceived as revolutionary. Well, certainly in her role in the courtroom as a black woman lawyer in Southern courtrooms during the era of Jim Crow, when she was trying to tear down Jim Crow, she was. But her ascent to the bench is mostly a story about personal success. Personal success that is significant. It tells us about the need to make sure that the judiciary is open to people of intellect and good character from all walks of life. And certainly that practice background should not be grounds for disqualifying anyone from a case or from the bench itself.
But even today, private practice remains overrepresented among backgrounds of nominees to the federal bench. Another thought is that symbolism matters a great deal here. So Constance Baker Motley may not have been a revolutionary on the bench, but her ascent to the bench had great symbolic significance for the nation. Motley recognized as much herself when she argued for inclusion of women and people of color on the bench. She said they should be included not because I think they bring something totally different to the bench than white men. Instead, she said, inclusion builds confidence in government. It makes people feel that government is fair, that it includes people from all walks of life. She believed in sharing power, as any good legislator would. So her appointment made people believe in America first. That's worth a lot, and it's still worth a lot. 4, Constance Baker Motley, not a revolutionary, but a real workplace reformer. I said that Motley implemented the Civil Rights Act through her work in the courtroom. Well, it's also true that Motley was one of the first federal judges to hire a diverse pool of law clerks. Law clerks had been white and male most often. She hired diverse law clerks, and of course, hiring those diverse law clerks opened up access for diverse lawyers in law firms, in academia, and in the judiciary. I've talked to all sorts of people who began quite distinguished careers in the chambers of Judge Motley. She mentored all kinds of folks. One of those people whom she mentored, by the way, is a judge herself on the Southern District of New York, Laura Swain. She mentored Justice Sotomayor, convinced Justice Sotomayor to accept an appointment to the Second Circuit at a time when Justice Sotomayor was actually a little shy about accepting because apparently she'd only been on the district court for a short time. Motley hosted a dinner party for her for the express purpose of saying, no, don't wait for another opportunity to come around. If and when, she said, one of us is presented with an opportunity to sit on the Court of Appeals, take the opportunity when it comes open. What about the outcomes? What can we say about the outcomes in Judge Motley's courtroom? Well, what I would say is that it's important to understand that for Motley, like for many, many judges, there were a complex set of variables at work that influenced outcome. Hard factors such as precedent, certainly for a district court judge, but there are other factors. You might call them soft factors, such as intellectual disposition, having been a legislator, her character and personality, religion. There's a whole political science literature on partisanship, which also comes in soft and hard varieties, you might say. The problem is that observers seem to think that if one is a woman or a person of color, all one has is race or gender. And I would submit that that is a problem. Of course, there are variables as well related to the cases themselves, the quality of lawyering, the identity of the parties matter in terms of status, wealth, whether the litigants are pro se. Many, many things matter in these cases, but a correlation between identity and substantive representation, not so much, which shouldn't come as a surprise. Because in as much as there are studies that show some correlation between gender and outcomes in certain cases, all of the studies on race, none of them show any such correlation. I would conclude by saying that all of the outcomes that I've identified, all of the factors that I've identified in Motley's career on the bench, including diversifying the professional network, are, of course, terrific. And yet, I do want to turn back to the question of equality in how it played out in Motley's career over the long term. Motley had started out as an individual who was deeply concerned about access and opportunity for the average person. She was deeply concerned about the working class and the poor. And at least as an initial matter, I think that what I'm concluding is that Motley's time on the bench ends up showing how, well, inequality is embedded in structures and in all of these other variables that I've been talking about, and it replicates notwithstanding the advent of a diverse bench. Thus, if it was true, as one reporter observed in 1963 of Motley, that her path of ascent was an only in America saga, then we should acknowledge that her saga involved a paradox of opportunity. Access was granted, but the price of entry was steep. On the bench, she could no longer, and perhaps no longer, had the same kind of inclination to struggle for equality in the same way. She had a different role, different constituency. Much had changed. So being first was both an honor and a burden for Motley and for her community. I hope I've given you some things to think about, and I'm eager for your questions and for your comments on this project. Thank you.
Thank you so much for a really fascinating talk. I think we have time for about 15 minutes of questions, if you want.
Yes.
So I have a question about what Judge Motley's aspirations at two decision points in her career tell us about forms of the availability of social change. And they're the point in time at which she wanted to be promoted to a leadership position in the Inc. Fund, and the point in time at which she moved from the Inc. Fund to state politics. You didn't say much about why she wanted what she wanted at those points in time. Why, for example, opt to be a institutional leader at the Inc. Fund, where you may be tasked with managerial responsibilities and bureaucratic responsibilities that may be less congenial to you as a lawyer. You might enjoy the work of going to of having clients and changing people's lives on the ground, right? How is she thinking about those two options? And again, how is she thinking about the litigation strategies that she had been pursuing at the Inc. Fund in relation to the opportunities, more open and more constrained along different margins, that are available in the electoral domain, right? So I think those are both moments where aspirations are in part a function of, or maybe are a function of, the available modalities of social change. But I wonder what your study or your work in the archives of her about her tell us about those aspirations at those points in time or other points in time.
So that's an absolutely vital question. And the initial answer that I will give to you perhaps will not satisfy your interest in social change. And here's why. Because it turns out that for Motley and for Thurgood Marshall and for Bob Carter, for all of those lawyers who had been working on these civil rights cases for so long, and it is hard, hard work. It's dangerous, dangerous work. A part of what they want simply is professional recognition. They want professional recognition. Nothing more, nothing less. That is a part of the story. And I think that because these people are in the public interest realm, we tend to forget that they are professionals. And a part of the story that one needs to tell about these nonprofit organizations is that the people who are working in them, of course, they have aspirations, they're altruistic, but it's also true that because of discrimination in the market for legal professionals, you have all of these terrifically talented people who are, they have limited opportunities, right? So in other words, there's a way in which they're thinking about professional and individual achievement that doesn't have necessarily much to do with these larger ideals, okay? And I know that, a lot of people don't want to hear that, but I've been studying this organization and these people for a very long time, and that's one conclusion that I've reached. There's just an awful lot of, as there is in any workplace, a lot of desire to be the person who's the head of the organization because you think that it's your turn, okay? But that's not all that's going on. Motley, in the context of LDF, she's reasoning in terms of process of elimination. So certainly she's better than Jack Greenberg if what you want as the head of LDF is a person who can connect with the community, right? She's concerned that LDF, that Greenberg, as against some other white lawyers who are, dedicated heart and mind, Jack Greenberg is not that person in her estimation, okay? So if Marshall's going to appoint someone who's not one of these civil rights lawyers who's connected to the community, he shouldn't be the one. So a part of it is that she feels like she has a connection to the community, and she certainly does. She is beloved. She feels like, think about the photos. She's there with King. She feels like, in other words, I'm saying, as sort of an intuitive matter, she has a pulse on a finger on the pulse of the community, and she can sort of plot strategy as the movement changes. So I think that's what she's thinking in that term. I don't know that she believes that she has some strategy already figured out that she's going to implement, and that's connected to the cases that she's been working on. As to politics, so that's a different kind of story. That's largely opportunistic. She is asked to run for office in Harlem by a gentleman with whom she had worked at LDF who had gone into politics in Harlem. And again, it's one of these circumstances where she knows that she's very good. And someone is needed to run on a ticket where if a good, smart person doesn't run, then the alternative is someone who, in the estimation of the Harlem politicos, will sort of make the community look bad. And so you could say that Motley offers herself up And of course, she thinks that political power is deeply important. She thinks that if there's going to be someone who can, be a power broker, who can sit in the room with white New Yorkers, she can do it. She can do it. She has the credibility. If she can handle, if she can cross-examine the segregationists down in Mississippi, she can handle Nelson Rockefeller or whomever. So that's her thought process. Yes.
I have a somewhat related question. I was wondering if you could contextualize your work with Ken Max representing the race. Do you see this story of Constance Baker Motley part and parcel of Ken Max's story about how when lawyers of color start to, or when in order to become professionals, they adopt this identity as a professional lawyer or judge that ends up taking over a lot of their identity as a person of color? And if that's so, what implications does that have for social change activists on the ground thinking about elections of people of color or other minorities in terms of like actual tools of social change?
So my story, I would say, is more bottom up. I would think about the constraints of professional role when she becomes a judge. I don't think those constraints are any different for her than they are for any other judge. That's the point I was making at the end, right? So people think that it's race, gender, that's all they have. That's what's in their back pocket. When are they going to bring it out, right? And ruin everything for everyone. When are they going to take over and decide for all the blacks or the women? And I'm saying that no, Constance Baker Motley grew up in New Haven in the shadow of Yale. Her father was from Nevis. She had a religion. She had a personality. She had an intellect. She was an individual. And she brought those individual characteristics to her lawyering, to her time in politics, to her career on the bench. So there's a way in which there's a tension between the story I'm telling and my analysis and Ken's work, I might say. I actually want to unpack the group identity. I want to see the individuals. I think there is great value in seeing the individuals. That is the moment in which we find ourselves, is what I would say. And I mentioned, Justice Sotomayor and how Judge Motley mentored her. Sotomayor famously talked about being a wise Latina woman. I could never imagine Motley saying that, which is not to cast any aspersion on Sotomayor. I just spent a lot of time talking about her dissent and shoot and appreciating that. It's just they're individuals, and there are different ways of negotiating the role, and all of them can lead to strides for equality. Different people for different times is what I would say. Yes?
I was wondering if you could comment a little bit methodologically on how you see your work as a legal historian. Speaking today, I saw you in conversation with a political science literature that I think often historians have not engaged in these conversations, even in the legal history setting, where there is, on the subject of judging, in a sense, parallel literatures developing in terms of kind of political science analysis of judging, and then kind of very qualitative historical methodologies. And it seems that what you just mentioned about the desire to press for a consideration of the individual is, in a sense, a major challenge to the methodological project of quantitative judging analysis. And I was wondering if you could elaborate on that.
Yeah, so that's a fair point. I think that those studies are quite blunt. And, you know, whenever those people, I spent time on a faculty with Lee Epstein, and she introduced me to this work, and, you know, I value the work, I value the mode of thinking. At the same time, I think it's blunt and misses all sorts of things. And although I'm doing a little bit with this, it's really just a small bit. And as I said, I think it can be valuable, but it's a supplement. And I'm always sort of dissecting it. So as I said on that slide, you know, liberal, conservative, well, that I can't do that. I can't believe that got past me. You know, I hate that kind of thing. So it's just a tool when you're faced with, you know, someone, I think Dean Schill said, you know, when are you going to be done with this book? You know, we're talking of hundreds of cases and, you know, 3 different careers, and you have to try to not just read the cases and do the kind of nuanced analysis that historians do. You have to try to get the big picture, and so that's what I'm trying to do. And also trying to be in conversation with people who don't necessarily think of, you know, reading a legal history of a judge, although an important judge, an historic judge in many ways, as speaking to anything that they care about. If you start to compare a single judge to other judges and think about district courts and not just about, you know, what this particular judge was doing, you can get some leverage in, you know, with a broader audience. And I think it's important to do that. And it's also true that I just like to be read outside of a narrow field. And, you know, I'm interested in con law as well as legal history. And so I try to, as a matter of methodology, bring lots of different approaches together.
Well, there are many more questions, but hopefully we can continue the conversation at the reception outside. Please join me in.